Greetings to all present here. My name is Ankit Malhotra. I am the co-founder and president of the Jindal Society of International Law. It is my honor and privilege to have and host a reputed and respected professor amongst us. In fact, this tradition of hosting professors from the university goes back to the very inception of our society, and we're so grateful to have professors such as those who we have today amongst us. But before I introduce our speaker, I would like to share a few words about the Jindal Society of International Law, which is a student-led initiative under the aegis of the Center for UN Studies and under the guidance of Professor Dr. Weston Babowski. We were founded in 2020 as a student initiative and provide a platform to young international law enthusiasts. The inaugural address of the Society's launch was given on the 18th day of November in 2020, and we hosted the Herbert and Rose Rubin Professor of International Law, Jose Enrique Alvarez of New York University, along with our Vice Chancellor, Professor Dr. C. Rajkumar, the Faculty Coordinator, Professor Dr. Weston Browski, and the Dean of the Office of International Affairs and Global Initiatives, Professor Dr. Mohan Kumar. The purpose of this society is to increase student interaction with subject matter of international law through its various initiatives. Rather than being primarily research driven, we intend to offer a host of experiences that contribute towards skill building, thereby increasing the knowledge database available to the student members of our society. About this colloquium, I would also like to share that the spring lecture series of 2022 entitled "A Colloquium on the Challenges to Global Governance and Humanities in the 21st Century" offers a compendium of scholarship from the academy and also professional experiences from the bar. Over the past year, the Jindal Society of International Law has hosted 100 speakers from renowned foreign universities, members of the International Law Commission, the international law firms, United Nations Institute of International Law, World Bank, and the Hague Academy of International Law. Through our previous series, we endeavored to study the different contours of international law through the speakers who covered and addressed their respective areas of expertise based upon the years of research and practice. Given the vast ecosystem and the engagement of international law in it, the Society aimed to study the fragmentation and fertilization of the various disciplines in the ecosystem of public and private international law. Over the years, the Society has become a quorum of thought-provoking discussions due to the engagement of experts aimed at exploring the ecosystem of international law in it. Thus, as a result, through the spring lecture series, it is important to understand the law and its challenges from broader, different, and differing vantage points. Acknowledging international law as a creation of states, it is also important to understand and appreciate the social sciences and the humanities that have played a role in shaping the law. Thus, a broader study becomes critical and also crucial. Through the series, it is hoped that one will develop a deeper understanding of Philip Jesup's magnum opus, A Modern Law of Nations, an introduction in 1949, when he said, and I quote him, "So long as the international community is composed of states, it is only through an exercise of their will, as expressed through treaty or agreement, or as laid down by an international authority deriving its power from states, that a rule of law becomes binding." End quote. Today, to speak on the coming conflict between cybersecurity and commerce, we have Professor Joel Trachtman. Professor Trachtman has been a professor of international law at the Fletcher School of Law and Diplomacy at Tufts University since 1989. A 1980 graduate of the Harvard Law School, where he served as editor-in-chief of the Harvard International Law Journal. He practiced law in New York, Hong Kong for 9 years before entering the academy. From 1998 to 2001, he was an academic dean of the Fletcher School. During 2000 and 2001, he served as dean ad interim. Professor Trachtman teaches courses in commercial law, including international business law, international financial law, international trade law. He also serves as the co-director of the Center for International Law and Governance and as a member of the Tenure and Promotion Committee and the Academic Council. I will not be surprised if there are prototypes that Professor Trachtman has to keep track of the amount of work he does. Professor Trachtman is also a world renowned authority on international trade law and has pioneered the application of economic analysis to international law. The author of 100 scholarly articles and chapters, has published 10 books, including publishers such as Harvard, Oxford, Cambridge University presses. He served as a member of the boards of leading journals in international law, including the American, European, and the other journals of international law, such as also the Singapore Yearbook of International Law. He consulted for a number of governments and international organizations, including the United Nations, World Bank, and the OECD. He has been a visiting professor at Basel, Hamburg, Harvard, Hong Kong, Pretoria, Swansea, and Hebrew University, and he has lectured at other leading universities around the world. He frequently also comments on the current international commercial law issues. With those words, I invite Professor to start his elocution, and we shall then have a round of questions, although I do encourage our participants to share the questions in the interim as well, which we can take up in the end. Professor, the floor is now all yours.
Thank you very much, Ankit, and it's an honor and a pleasure to be here with you. And the title of this talk, The Coming Conflict, may be a bit too optimistic. I think it's probably fair to say that the conflict is here already. And what I'll do now is share my screen. Can you confirm that you can see that all right?
So, we can.
Okay. So this topic is one about cybersecurity and commerce. And by commerce, I mean trade and investment. And as the world globalizes, as it integrates, as commerce from one country to another penetrates different territories, we have the risk that cybersecurity will be challenged. And so this topic is, how do states manage that particular risk? How do they deal with the fear that when they accept goods from abroad or investment from abroad, those goods or investment could be as you might say, a Trojan horse that could be used in an attack against them. And so the question is, how do states protect themselves? But the other side of the question is, how do states maintain the commerce that benefits them going forward? So this is the motivation, that there is a fear that the modern demands of cybersecurity and geoeconomic security is the sense that there are technological competitors. And here in the United States, where I sit, there is a growing concern of China as technological competitor in robotics, in artificial intelligence, in other advanced technologies, which are increasingly being seen as technologies that are critical to weapons systems. And so the question is, how do you, as a security competitor, prevent your opponent from attaining technologies that will allow that opponent to overcome you militarily while still maintaining commerce? So that's a core question for states today. And what I'll propose to you is that current international trade and investment law is not fully developed to manage this concern. And so there's more that can be done in that area. So let me begin with trade in goods. And we can think about two kinds of Internet of Things type goods. The first kind are high-risk goods. Think about industrial controllers or airplanes or even automobiles that could relatively easily be weaponized, could be used to engage in destructive attacks. And then there might be lower risk kinds of things like children's toys, although children's toys can serve to compromise privacy and could even be used to attack higher risk types of technologies. So the separation is not so very clear, but it's important to recognize this category of higher risk, because it's possible that the lower risk kinds of goods could be addressed through ordinary regulation, the way we regulate the wholesomeness of foods or the safety of electronic goods from fire and so on. And so it's important to have international trade law that can manage the trade effects of ordinary regulation, but we also have to think carefully about the management of security risks. So let me give you an example. It's not exactly Internet of Things, but it's quite similar. And that is Huawei 5G equipment. And many countries, including the United States, Australia, India, have had concerns about the risk of foreign control of national telecommunication systems, concerns about privacy, about security, about being disabled at critical times, about being weaponized in various ways. And 5G is also the backbone of the Internet of Things, so it's a real infrastructure for security. And so what can states do to accept these goods, which are useful and maybe efficient in other ways, but that present security concerns? And what the UK did early was to establish a cybersecurity evaluation center funded by Huawei, quote, under a set of arrangements between Huawei and the British government to mitigate any perceived risks arising from the involvement of Huawei in parts of the UK's critical national infrastructure, end quote. So the idea was to have a way to look into this 5G equipment to make sure it was safe. And so there was this place and an oversight board, and the oversight board assessed the independence of the place and its work and the competence of this place and its work, and assessed the risk from products. But what they found was that they could look at a particular piece of equipment, and this is all about software. They could check the software, but they couldn't evaluate whether there would be a, quote, consistent build to evaluate the software itself. And they couldn't secure the chain of custody, and they couldn't evaluate updates. So because software, and in order to be secure, software has to be updated from time to time, because it's constantly updated, and it's possible to change it very easily, it's not possible to really check the software for something like that and be confident that that checked software will be replicated in every item that is imported. And then it's important to state that importing states, or states in which investment might occur, could have mixed national motivations. And this is a mixed motivation context where there are ordinary regulatory concerns about privacy or other desires. There are security concerns, but there are also competitive concerns and the kinds of geoeconomic concerns I mentioned before. And so the Internet of Things, trade in these connected goods, is a threat to security, but the security concerns are a threat to trade. And so we need to manage those things and integrate our concerns in a way that maximizes value to groups of states. So what can states do to protect themselves? Well, they can ban all Internet of Things products, including domestic ones, because those might be produced in a way that's compromised. They could establish product standards for public procurement for things that will be used in governmental activities. They could establish product standards for private procurement, say to your private telecoms companies, you have to have only safe kinds of products, or industries, your industrial controllers have to be safe. They have to be from national producers or from trusted producers. You could establish producer standards and say, we're going to evaluate particular producers to see whether they're sufficiently trusted to allow procurement from those producers. You can restrict foreign investment in your own Internet of Things production and then say, well, if it's produced inside my country, it's okay. And there are all sorts of combinations of these strategies that might be utilized. So what are the trade law issues with some of those strategies? Well, if you think about the relationship between China and the United States, which is a core relationship in this area of concern, China might say, or the United States might say, that the other is discriminating against its products. And under the General Agreement on Tariffs and Trade, which is an agreement under the World Trade Organization, and the Technical Barriers to Trade Agreement, another WTO agreement, or the General Agreement on Trade and Services, another WTO agreement, there are requirements of national treatment, treating, in this example, Chinese producers and Chinese products and Chinese services, as well as you treat domestic producers, and most favored nation treatment, treating Chinese producers, services, and products, as well as you treat, say, British or Indian or Australian products. And so that there's a question whether regulation can be structured in a way that complies with these anti-discrimination rules. And you can imagine Chinese producers like Huawei saying, you're discriminating against my products. And you've structured your product standards in a way, or your producer qualifications in a way that discriminates against my products. The Technical Barriers to Trade Agreement, which applies to product standards, adds a requirement of proportionality, that those product standards can't be more trade restrictive than necessary to secure a legitimate governmental purpose. And it also requires that if there are international standards, which there really aren't in this IoT cybersecurity field yet, but if there are international standards, then you can't have a national standard that exceeds those international standards unless you have a good reason in terms of your legitimate regulatory goals. There's a WTO government procurement agreement that some countries are party to that also could be violated. Now, these agreements and the WTO overall treaty contains these agreements, but in each of these agreements, there are slightly varying provisions for general exceptions and slightly varying and sometimes no provision for security exceptions. And I'll review some of those in a moment. So under GATT, the Technical Barriers to Trade Agreement, the General Agreement on Trade and Services, we think about discrimination in the national treatment and in the most favored nation sense by thinking about whether the products or the services or the service providers are sufficiently similar to merit equal treatment. And then we define the likeness of their products, the similarity, by reference to competition. We also define the quality of the treatment, the question of whether the foreign person or good is receiving less favorable treatment by looking at the effects on competition. So here, it's important to say that there's little room to include the regulatory purpose in this analysis of whether there's discrimination or not. So if you treat Chinese products differently from the way you treat United States or Australian products, and it has a a bad effect on Chinese competition, then you would have a violation. So there's little room for the regulatory purpose. There may be a good regulatory purpose. You might say, well, we're security competitors with China and we're worried about cyber attack. And so we have a legitimate purpose. But here, if consumers fail to distinguish, which they often do, that's the reason for regulation, we could have a violation of national treatment or most favored nation treatment because we use consumer perceptions as the measure of competition. And then the technical barriers to trade agreement, the TBT agreement, contains no general exceptions. So because of that, the WTO appellate body, its Supreme Court, understands that a little differently. It says it's not less favorable if it stems exclusively from a legitimate regulatory distinction. This is because the general exceptions in the GATT allow different treatment based on legitimate regulatory distinctions, and there was nothing like that in the technical barriers to trade agreement. So in order to protect appropriate regulation, the appellate body identified this somewhat different understanding of what amounts to less favorable treatment. So there's, I think, here questionable space for states to regulate or to surveil the production process of these types of Internet of Things products or services. And distinctions based on the location or the identity of the producer, including the quality of the foreign country, of the home country regulation, or including statecraft security issues, would ordinarily violate national treatment or most favored nation treatment. So from there, we have a risk of violation. We have to see, is there some exception? And as I've said, in the technical barriers to trade agreement, which covers product standards, there is none. If there's a violation, it simply is a violation. But in the GATT and in the GATS, there are both general exceptions and security exceptions. So I want to say that in a relevant case brought by Panama against Argentina in connection with Argentina's financial services regulation, the question was whether Argentina could distinguish services from Panama based on tax regulation in Panama. And there, I think it's interesting that the appellate body refused to make a finding on whether services of companies from non-cooperating countries like Panama are sufficiently like in relation to services of tax cooperating countries or Argentinian companies. So here, the analogy is that the regulation of the home state could not be used as a basis or wasn't found to be used as a basis for determining whether those services are sufficiently comparable to merit equal treatment. So it's analogous to the question of conditioning market access on the security status of the home country or its regulation of cybersecurity in Internet of Things products. So let's turn to the general exceptions in the GATT. And here, there are exceptions for measures that are necessary to protect human life or health, or necessary to enforce laws, including those to avoid deceptive practices. And those exceptions are subject to a chapeau, an overarching requirement of reasonableness and non-arbitrariness. And so the question here is differential treatment of different home countries reasonable? Or do you have to do more? Do you have to be reasonable? Do you have to manage? Do you have to mitigate the restrictions? So how does that restrain national restrictions on imports? And the necessity word in Article 20B and 20D of GATT has been interpreted to provide either a least trade restrictive alternative test. Is this the least trade restrictive way for you to achieve your regulatory goal? Or a balancing test, balancing the different equities. And it's similar in the GATS, the General Agreement on Trade and Services, with respect to services that might pose a risk. And then let's turn from Article 20, the general exceptions of the GATS, to Article 21 of the GATT, the security exceptions. And there, the United States has traditionally had the position that the security exception was self-judging as a matter of sovereignty and non-justiciable. That position is inconsistent with the original negotiation position that the United States took in 1947, but be that as it may. Here, the language of Article 21, the relevant language, says a state may take action which it considers necessary for the protection of its essential security interests, either relating to traffic in arms and implements of war, or in time of war or other emergency in international relations. Well, cybersecurity concerns often arise ahead of there being a war or an emergency in international relations. And the relationship to traffic in arms, these are perhaps dual use goods. They're not necessarily exactly the same. We might say that these things are now understood as implements of war. And so we can restrict traffic in implements of war under that provision. So as I said, the United States has traditionally taken the position, along with Russia, strange as it may seem, that this provision is non-justiciable. But the panel, the WTO panel decision in a case between, strange to say, Ukraine and Russia on trade in transit found that indeed this provision is justiciable. Panels and the appellate body can make decisions about it, so it's not self-judging. And the parameter of whether there's an emergency in international relations is objectively, judicially determinable. In that case, it found that there was an emergency in international relations, but that the essential security interests idea relate to the quintessential functions of the state, and the invocation must be specific and must show that. So here, we don't have an interpretation of what it means to have implements of war, what it means to relate to traffic in arms, ammunition, and implements of war. And that may be more relevant to our concern, but it does suggest that that test will not be self-judging and will come up for adjudication. So let me summarize on these trade exceptions. For low-risk Internet of Things, think about children's toys, there's either no violation of WTO law because you treat everyone the same, or the general exception might be available if you comply with the parameters of Article 20D or 20B, that it's necessary under the chapeau, that it's not arbitrary or unjustifiable discrimination. And here, as I said, the question would be whether singling out China would be arbitrary or unjustifiable. And we have that precedent of the Argentina Financial Services case to think about in that context. For high-risk Internet of Things products, truly dangerous products or directly dangerous products, the security exception under Article 21B3 for an emergency might be available, or more likely under 21B2 for implements of war, and there also might be an exception under 20B. As I said, the TBT agreement lacks general exceptions or security exceptions, so we have a tougher question about compliance there. So the GATS and the government procurement agreement track the GATT with some exceptions that need not hinder us. So let's turn to foreign investment. So we've been talking about trade. I've suggested that the law there is somewhat indeterminate. It's unclear what kinds of restrictions states are permitted to have under WTO law, and the same would be true under preferential trade agreement law. So let's turn to foreign investment. And here again, there are two kinds of threats. One is the cybersecurity threat that investment in a high-tech enterprise might be a vector, a vehicle, a Trojan horse for cyber attack. And we can think about establishments, we can think about industrial controllers, we can think about production of goods that pose a threat, or provision of services that pose a threat. And then, as I said, there's also, in addition to the cybersecurity threat, a geoeconomic threat that you might be granting a security competitor access to weapons technology. And here we have a familiar kind of technique that's been practiced since the first Cold War, which is to impose export controls on exports of certain weapons goods and certain dual use goods. And you might translate that over to investment control and say, we need to do the same kinds of things with investment in our markets that we did with sending weaponizable or weapons goods to other countries. And so the idea is to avoid that Trojan horse type security threat. And different types of host states will have different risk profiles vis-a-vis different types of home states. So we'd have different kinds of concerns depending on the states involved. What are the potential legal concerns, the potential breaches of international investment agreements? First, let me say this is dependent largely on there being a bilateral investment treaty that is applicable. And most bilateral investment treaties have provisions, again, for national treatment of foreign investment, possibly at the time of establishment, so market access for foreign investment, and most favored nation treatment for establishment of foreign investment. And then post-establishment, once the investment is there, again, national treatment and most favored nation treatment. And then prohibitions on expropriatory takings without adequate compensation, and requirements for fair and equitable treatment. And I'll just note, I know that the government of India has been questioning and revising its approach to these bilateral investment treaties. So thinking about the United States and China, there's no international investment agreement between the United States and China at the moment. But let's think about what might occur. So the United States has an autonomous, a domestic law called the Law on the Committee on Foreign Investments in the United States, CFIUS. And that contains restrictions on foreign investment, a possibility for evaluation of the risks posed by a proposed foreign investment, requirements of mitigation of those risks, as a condition for making that foreign investment, and some discretion in that committee to permit or not permit foreign investment. And so, as I said, there's no international investment agreement right now between the United States and China. But if the United States and China were to negotiate one, we would want to think about the security exceptions and how that would allow both China for its part and the United States for its part to satisfy their national security concerns. So the United States has taken a number of actions with respect to China for national security reasons in the investment area under this Committee on Foreign Investment in the United States law. So Fujian Grand Chip Investment Fund was prevented from acquiring a United States subsidiary. Canyon Bridge Capital Partners was blocked from acquiring a United States company that sold semiconductors to the military. In 2018, we made stronger the CFIUS process through the Foreign Investment Risk Review Modernization Act, FIRMA. And one of the senators at that time, John Cornyn, said that FIRMA would help stop China and other bad actors, his word, his term, from eroding our military advantage by stealing or otherwise acquiring sensitive dual-use technology by investing in United States companies. So you can see that this was a real concern in the United States, focusing on critical technologies like artificial intelligence and robotics. A Chinese gaming company was prevented from acquiring the dating app Grindr due to privacy concerns and concerns about possible blackmail. And in 2020, Beijing Shiji Information Technology Company was required to divest itself of a US software company. And then, as you may know, because you had something similar in India, ByteDance, a Chinese owned company, was ordered to divest itself of TikTok because of concerns about security. So you can see these are actively used restrictions. Now, in these international investment agreements, as in the trade agreements, there are security exceptions. And to the extent that those security exceptions are self-judging, as the United States has wanted them to be, the Schmittian state retaining power to determine the exception is the fundamental power. That language, which it considers, that it considers, is what is understood to make it self-judging, non-justiciable. And the question is, what part of the provision does that language qualify? And so the question here is, are these security exceptions sufficient to allow states to protect themselves? And secondly, are they excessive? Are they overbroad in that they allow states to carry out trade protectionism or other policies that are not truly security? So you might use negative lists. You might say certain types of products will be forbidden in connection with foreign investment or imports, but those lists can be under-inclusive and overbroad. Also, we're uncertain about the future, and so this is an area of incomplete contracting, and in a moment I'll say how it's a problem in contracting. So I want to illustrate the idea of under-inclusiveness of these security exceptions with the proposed EU-China Comprehensive Agreement on Investment, Section 6, Article 10. It says, nothing in this agreement shall be construed to prevent a party from taking an action, again, which it considers necessary for the protection of its essential security interests, and then a couple of limiting subparagraphs, and we've seen some of this language before, connected to the production of or traffic in arms and other things, and then taken in time of war or other emergency in international relations. And so here the question is it under-inclusive because it doesn't really address geopolitical concerns about technology in robotics or artificial intelligence? So is this under-inclusive? Do we need a tougher security exception? And then is it over-inclusive in the sense that it might be understood as self-judging? So the nature of the self-judging aspect of this provision here in this 2012 United States model bit is somewhat uncertain. It says nothing in this treaty shall be construed to preclude a party from applying measures that it considers necessary for the fulfillment of its obligations with respect to its maintenance or restoration of peace or security or the protection of its own essential security interests. So there you don't have weapon systems either. So this type of security exception was subject to a kind of comity-based equilibrium up until really the Trump presidency, I would say. And then beginning in 2017, the United States led the way in reducing its comity, in reducing its reciprocal forbearance from excessive use of this overbroad security exception. And you might say that part of this is the inadequacy of reputational constraints, as pointed out by my colleague Anna van Aken. You might say that it's just a deterioration in the fabric of international cooperation and international rule of law. But here we also have the loss of predictability of market access because of the potential abuse of security exceptions, and loss of the predictability of the continued viability of investment, making investment less attractive. So what is the contract theory problem that I mentioned earlier? It's a question of how to make security exceptions sufficient to protect valid, good faith concerns while minimizing the threat to investment or to trade. And there can be two related techniques. One is to say, yes, you can have whatever security exception you wish, but you must compensate for it. And actually, in the 2002 asbestos case, in connection with the general exceptions, the WTO appellate body held open the possibility that states that use the general exceptions might be required to compensate the states whose products were kept out because of those general exceptions. So a requirement of compensation would make states think twice, would provide appropriate incentives for them perhaps to mitigate the extent of the security exception, the use of the security exception, to maximize the joint welfare of the exporting state or of the home state, and the importing state or the host state. So there might be techniques for mitigation of the harm by virtue of assertion of the security exception. So requirements of compensation would be a little bit like efficient breach. It depends on the calculation of the damages. It depends on the ability to enforce the damages, but it might provide sufficient compensation as well. You might say that there's already in Article 25 of the Articles on State Responsibility some possibility of action and compensation, but that may not be available because it requires a grave and imminent peril. It's not clear that that applies well to cybersecurity or geoeconomic threats. And we also have the question of which harms are compensable, not the harm presumably arising from the denial of cyber attack or geoeconomic advantage opportunities. So there might be requirements for states that utilize security exceptions to mitigate the scope of their use of the security exception for investment. It seems to already be autonomously provided in the United States CFI-US law, but there are probably insufficient incentives for the United States to use it. Also, mitigation might involve restructuring the investment, but it might also involve undertakings by the home country government in addition to the investor. So, for example, both Chinese and United States governments today might require disclosures from their investors. For China, under Article 7 of its National Intelligence Law of 2017, they might agree to avoid doing that in order to make the foreign investment or the imported good less risky. But there's no requirement for any mitigation or compensation in the WTO or in the BIT security exceptions. So the question is, do we trust or verify? So I've been suggesting that there be some attempt to revise these security exceptions to promote investment and trade while preserving and in fact ensuring sufficient flexibility for states to defend themselves appropriately, and arrangements for compensation and or mitigation might be useful in doing so. Uh, Here, one avenue of mitigation is to focus on trust, especially for geoeconomic competition. And here, the model is modern export controls, which focus on the end user. So can I trust the end user to utilize these goods or technologies subject to export controls in a safe way? And then for cybersecurity, uh, to focus on verification. And I mentioned that the British had problems doing that with Huawei 5G equipment, but that still is an important possibility. To focus on software systems, including access, and to try to make sure that the software systems are sufficiently transparent and verifiable to allow them to be admitted. Well, thank you for listening to me, and I look forward to comments and questions.
Well, Professor, let me just begin by thanking you for your most excellent and thorough presentation, which leaves very little room for questions because one has a good grasp, all thanks to your presentation. But I just have one follow up, which sort of is the general consensus, and I think even the Hague Academy lectures in the past year focused on the cybersecurity space, and Professor Theodore Christakis focused his lectures on those. And the real consensus, or the consensus building which is taking place in the European sphere, is with respect to coming up with a framework on how to deal with cybersecurity and cyber threat. But perhaps with the COVID-19 pandemic, ransomware has become exacerbated, and I'd be very interested to know what your take will be on that, because that's a very common problem, and it affects the lives of those who belong to a certain class of the general population.
Yes. Well, you're right. It's a pressing problem, and it's a growing problem, and it raises the question of what to do about non-state actors and how to attribute state responsibility, because some of these ransomware attacks are truly private, and you might compare them to private pirates. But some of them are pirates acting under letters of marque from governments, and so I think those are distinct cases. Where they're truly private, I think it's important to develop techniques of cooperation among states to enforce laws, to engage in surveillance, to identify those people, to capture their Bitcoin, to recapture their Bitcoin when they get the ransom. And that's a kind of an international police cooperation problem. Where the private actor is acting as a proxy for a government, that cooperation won't be available. And there it's part of the broader problem of intergovernmental international cybersecurity. And we have to develop norms of transparency. Private companies like Microsoft or Google are active in trying to promote those kinds of norms through the Paris process and other venues. But that's a tough one, and it's both hard to surveil and hard to attribute damage to governments, and it involves a great deal of expertise that countries like India and Russia and Iran and the United States and China have, but not all countries have that kind of expertise resident. And actually, a company like Google is probably better at that kind of thing than most countries. And so it's one of those interesting areas where public-private cooperation appears useful. And in the Fletcher School's Center on International Law and Governance, we recently had a conference on multi-stakeholder diplomacy in that area to develop and enforce cyber norms. And the idea was to think about the role of some of those private companies. But I think it's a problem that today has not been resolved.
As a matter of fact, my second question, or sort of query, was with respect to the involvement or dependence on private actors and other parties. But this comes at a very crucial junction, at least for them as well, with respect to these giants in the tech world, like those of Facebook and also Google. When there is so much angst against them, in some sense their situation resembles that of those tobacco companies like Philip Morris, who we even spoke about. So on one hand, you're asking them, these companies who sort of in some sense produce the new cancer, trying to draw an analogy here, and then you're also asking them to build hospitals. So it's a little difficult, at least to my mind. I do completely understand this trajectory of thought, but and it's extremely pertinent in countries like India and Bangladesh and South Asian countries, where Facebook is an integral part of not only social interaction but also commerce and e-commerce, which goes to show how deeply these social media giants have sunken into our society and social fabric. So in that sense, the interesting part about South Asia and especially India is that ransomwares are usually made by by those in my country. So then it becomes a very difficult situation, because the ransomware requests are being made from certain parts of the country, but then you're also asking them to have this system of governance as well. And that, in that sense, what the Chinese example of the firewall is, does not seem like that bad an idea. So that's a very pernicious line of argument. I'm being provocative just to see how deep the waters are and to get a pulse of where or what might be the solution here.
Yeah. Well, I think you're right. The world is heading, if we don't do something, towards a what some have termed the splinter net, where we'll reestablish borders through firewalls. So there'll be a United States internet and a Chinese internet and an Indian internet, and they won't really connect. I think that will immiserate the world, or at least reduce global welfare significantly. And so I think that the better alternative is to find ways to cooperate and to avoid attacks and to avoid capabilities for attacks that would make it necessary to have those kinds of reestablished borders, and to really, turn away from globalization, turn away from the globalization that these things provide. So I think it's a big task for international lawyers to try to work on this, and for diplomats. And it involves many different regulatory issues. We have privacy, we have consumer protection, we have intellectual property protection, we have cybersecurity, we have geoeconomic weapons denial for competitors. And so there are a number of different issues that come up in this space. And so it's necessary to have diplomats and international lawyers who can work across functions and can work with people with expertises in other functions to do this. So it's a big task for modern diplomacy, and one that has no real precedent, although we can say that it's not so different from piracy. It's not so different from ordinary war and ordinary weapons, but it has a kind of increased salience. You might say that the internet makes us more integrated. It's globalization on steroids. Globalization of goods and services just crosses borders, at a certain level of frequency. If we're doing it through the internet and more intensively through the internet, it's greater interaction. And so it requires us to have greater regulatory cooperation in order to maintain that globalization, which brings us greater welfare. So, you raised the question, what about these companies? Well, we need to regulate them too, from a competition standpoint, from a tax standpoint, from the standpoint of election security and free speech and so on. And so it's a big task, and I think that, as I say, there are multiple ways in which we need to regulate them, and multiple states that they touch. And so each state might say, I want to regulate Google in my way. And then, one of the things that's interesting, I don't know if you've seen, Anu Bradford at Columbia Law School has this book, The Brussels Effect, and it seems as though for some kinds of technologies and some kinds of contexts, a state or a jurisdiction in this case can be a leader. And if they're big enough, and if the technology is global enough, and the company regulated is global enough, if they regulate in a certain way and say, in order, in the privacy area, in order to move information outside of Europe, you have to have similar kinds of rules. There's a kind of replication of that, and other people have begun speaking of a Beijing effect. And so there is some autonomous, and there will be some more deliberate harmonization and centralization of rules. And the question is, are we doing it enough to have the kind of world that we want? And as I say, each country is different, and each country wants a different world and prioritizes different values. And that's, a topic for negotiation. And it may be that we can find ways to agree. It may be that where we can't agree, we can establish more modest Great Walls of China to keep out the things that we can't agree on.
So borrow the principle but adopt a measure which suits your own jurisdiction. But on the count of jurisdiction, what you say is quite interesting, and specifically this word which is referred to, space. So space is, so internet predominantly was supposed to be a free space, or there was no sort of liability to be attached, irrespective of what you said. And look how far we've come. Uh, my question, and I do encourage others to share their questions as well, um, is with respect to jurisdiction and cyber criminals. So then, do we go back to Lotus, and do we trace jurisdiction from there, or do we adopt an advanced position of jurisdiction for cyber criminals? Where does the position on jurisdiction rest, or is it like the hot pursuit? So then, wherever it goes, whoever it has a claim on it, or will it be like a governance obligation which rests on all party states?
No,
Again, piracy being an important example
right,
here. Piracy
right.
will then come a very heavily loaded term with multiple
Yes, indeed.
connotations.
Yeah. So I think it's an important question, and I think that we will have to develop principles of allocation of jurisdiction, allocation of legal authority, and it may be that the European Union is a model here, where we have a certain level of harmonization and then rules of mutual recognition that say, once we've harmonized sufficiently, The home state, however defined, will have the principal regulatory authority and responsibility. But that it's a really good question, and I think we do have to come up with principles of allocation of jurisdiction. And then, as is implicit in your question, there are externalities of each state's behavior. So if my state allows piracy that attacks your state, and I have the physical authority over these people, then we need an international legal rule that gives me more responsibility to restrict them so that they don't impose harm on you. And so the Lotus principle, as you say, is a principle that says there's no restriction on states' exercise of jurisdiction unless customary international law or treaty law has provided that limit. So we start with great freedom of states to act, but I think that there's the risk of excessive jurisdiction and excessive multiple jurisdiction. And so we'll need, I don't have much faith in customary international law arising in this area. We'll need treaty law that addresses these questions.
Thank you, Professor. It's been absolutely riveting hearing you and also your expert opinion in the latter part of this discussion. We're so honored and highly obliged to host you. We do extend a warm welcome and invitation to you to India and to the university, which will now be opening, and we will be having a hybrid system and hope everything shall be fine. Thank you so much for your time. Last words, and then we can close.
Thank you very much, Ankit. It's been my great pleasure to have this conversation with you and your colleagues.
Thank you. Thank you so much, Professor. And thank you to all those as well who have tuned in and have participated in this discussion. Thank you, everyone. Thank you. Good evening.